Hi guys, it's Kathy. Hopefully I'm not crackling, or in a submarine, or underwater, or no sound. Hopefully we just have sound this time. So, we are still, um, we're on January 30th, so it's Monday, the weekend is over. We did 20 minutes of this video last time, where Cochran was up saying he was going to conclude. They're still fighting over the new discovery that the defense sprung onto the prosecution after opening statements. So they're still trying to work through that issue. Um, I don't know what happens now. I don't know if Marcia gets back up now that Cochran went up again or what, but we'll find out right now. Here we go.
Ms. Clark, I think what I'm most interested in is hearing what your contemplation is of your proffer regarding a reopening of opening statement.
When we contemplate,
Yeah.
we have amassed information on several of the witnesses mentioned by Mr. Cochran that allows us to understand precisely why he hid them the way he did. And we are going to prepare those remarks for the court. We've been assembling that information over the weekend, and now that we're finally in possession of the court's ruling, we will address what the court asks us to address.
What about why the defense hid them the way they did? So she has proof they did this on purpose? Oh no.
And we're going to have to put that together in a form that will allow me to succinctly state to the court what the points are that we intend to address with each witness. I would simply indicate that the statement taken from Marianne Gerchis most recently reflects the fact that counsel alone was in possession of her statement, that she asked counsel to turn her statement over to the prosecution, and counsel for the defense never did. She indicates very specifically that she spoke to Mr. Hostetler, whom we knew to be one of the investigators for the defense, and she told him that she wanted them to turn the statement over to us. So even the witnesses asked to do that, and the defense willfully refused to do so.
Well, Ms. Clark, you're arguing an issue and ruling that the court has already made. I've already made a finding adverse to the defense. I've granted a large number of the sanctions that you've requested. I am going to instruct the jury that a transgression of the law of discovery has occurred and has been part of the cause of the delay.
I think that
So to argue the basis for the court's ruling at this point doesn't help me a lot. What I need to know is, assuming I am willing to allow you to reopen, since this is a highly unusual remedy that you asked for, and the fact that there's only one civil case that deals with that, I've never seen a case allowing reopening after a discovery sanction has been imposed.
when has the court
And
seen
I
an
looked.
abuse? But when has the court seen a
Well-
violation this severe?
You're arguing.
Okay. Well,
I've already ruled in your favor, Ms. Clark.
Okay.
You don't
I'm-
need to tell me how severe it is.
Okay.
You don't need to tell me what the basis is. I think the ruling speaks for itself.
Victoria, does a court coordinator ever do stenography? Did you ever sit there like this for 8 hours, Victoria? If Ramona was out, could you pull out one of those old things and be her backup, Victoria? Victoria would get one of those happy birds, that just peck and go back up. You put water in them. She would just have a happy bird at the stenographer machine. Judge would ask her later to read back what they wrote. I don't know. I don't know if it kills your wrist because she's just like flowing. It's like flowing. It's not like she's. I don't know.
It does.
Especially given the nature of the court's finding as to intent and tactical advantage, which is as harsh a finding that the court can make under these circumstances. So my question to you is, if I grant your motion to reopen, what are you going to say to the jury?
And,
That's the bottom line.
all right, and I've asked leave of the court to,
And what I would anticipate you are going to say is that you're going to tell the ladies and gentlemen of our jury, had the prosecution known of these persons, we would have told you about them X, Y, and Z. And that's what we're going to prove. I think that's about the maximum parameter that I would entertain. And I stress the word entertain.
okay.
All right, at this point, then, I would suggest that we proceed then with the conclusion of Mr. Cochran's opening remarks, and that after the lunch hour, you'll have the opportunity to come back and ask me to reopen, and I'll rule at that time based upon your proffer after I hear Mr. Cochran's objections. I
Let
would
me-
suggest that, so we can make good use of the court time since we have our jurors seated, ready, willing, able to go.
I would
You
like
want
to
to discuss that with Mr. Darden for a moment?
May I address the court further concerning the expert witnesses?
Certainly.
Mr. Cochran indicated just now that some of the experts have not even examined the evidence. And I find it incredible that any officer of the court could stand before a jury and represent what conclusions and findings have been made when the experts have not even conducted an examination. That assertion that they have not even examined the evidence is incredible to me. If that is the case, and he's made representations as to what their findings are, I think that there's a great deal of credibility lost with respect to those witnesses. Obviously, it's going to be a bootstrapped conclusion. Counsel, who is not an expert, can stand up and tell this jury before an examination of evidence is conducted what the result will be. I find that remarkable. And I think the jury should be informed of that fact.
Well,
I think they
Ms.
should be
Clark-
told, Your Honor.
Ms. Clark, that's an interesting point, but I don't know the full parameters of what it is we're talking about until the disclosures of expert witness lists have been accomplished as I ordered today. I can always re-instruct and re-admonish the jury at any time during the course of these proceedings. You can also bring up during the course of your closing argument that contradiction.
I'm aware of that, Your Honor, but that doesn't address the harm that's already been caused in that counsel has indicated to the jury certain experts exist who will testify to the following, and we had no knowledge and no prior discovery of any, not even their names. Only this morning, because the court indicated it had a suspicion about who that was, did we find out what that was. Now
Well,
he
it's not
tells
a
us.
suspicion, it's just a logical conclusion from what we already all know about the case.
Okay, but that does not comply with any discovery law that I'm
This is
aware
true.
of. All right. So counsel is indicating now that he's going to testify to tire tracks and to shoe prints that were found at Bundy. We have absolutely no report, no knowledge, and no information that any such testimony would be forthcoming. Those should be included in the discovery sanctions as well. With respect to Lenore Walker, I'm particularly surprised and dismayed at what counsel has represented to this court. Counsel represented to this court when last we were here that Lenore Walker was only contacted for the purpose of testifying in this matter in January.
However, John, remember, like, there were cell phones back then, but not like smartphones, not like we have now. So human beings back then were used to sitting in a room without being entertained 24/7. They were used to talking to people beside them. They were used to reading a newspaper for a while. So they're okay. They're fine.
Just a few days before the discovery hearings occurred. That's false. It was stated in the Los Angeles Times by Dr. Lenore Walker herself that she was retained by counsel in the summer of '94 and that she has spoken to the defendant for hours in preparation for her testimony. So the violation is even more flagrant with respect to her. At least that's according to what she said to the LA Times. So counsel is now continuing to perpetrate a fraud upon this court, is continuing to make misrepresentations concerning the nature of the witnesses that they have contacted and their involvement in the case. He is still withholding more information. There are witnesses whose names we still don't have, and obviously there are no reports. That's a flagrant violation of the law, and now it's compounded by counsel's willful assertions to the contrary of what the witnesses are telling us in terms of when they were retained. How can that be, how can that possibly be swept under the rug? The jury should be told all of this.
Tell me about the LA Times information about Lenore Walker.
That's an article in the LA Times today, I understand. Or yes, was it yesterday or today? I have it upstairs. I believe it's in the Sunday Times, Your Honor. And if the court would like, I can have it brought down.
I'd like to see it.
I will.
But before we, Mr. Cochran, you indicated a desire to address that specific issue. I'd be curious to know.
I think I read the article, and what it indicated, first of all, it said, if I recall, Dr. Lenore Walker had known me since the time I was assistant DA and worked in this office, in the DA's office, that she and Geraldine Butt Staley worked on cases that I'd had the battered woman syndrome as a defense in other murder cases.
You got the wrong place, Gwen. This is when Nicole Brown Simpson died. This is the other people who died, remember?
It also indicated that she was contacted, I believe, in December, but she was not retained or brought forward in this case, Your Honor, until after you ruled on the domestic discord. It didn't make any sense. We didn't need her until that point. We don't have a report. The court checks Your Honor's records when we made an application for Lenore Walker to go into the jail to see Mr. Simpson, along with Geraldine Butt Staley, who saw him, is not even concluded, saw him as late as this past Friday. The court will know the time she went to see him. We don't have a report, and she came about. She's only relevant, Your Honor, after you ruled in the domestic discord. I've known her for some time, but she's not relevant in this case until that time. So I think I'm more than happy. She was probably talked to. I called her the first time in the fall, but she didn't get involved in the case until after the domestic discord. And I knew her since 1968.
All right. Ms. Clark, let me ask your staff to bring down the LA Times article, although obviously that source is hearsay.
Let me also indicate that with respect to Mary Ann Gerches, in her statement to us, taken most recently after counsel's opening statement, she indicates that she turned over her day runner, that's a daily calendar.
I know what a day
counsel.
runner is.
Okay. And that has never been turned over to us. In fact, it was never even mentioned that they had it. She indicates that she turned it over to them, and they have never turned it over.
All right. Well, I can see this is going to be an ongoing procedure here. Ms. Clark, however, I think my suggestion that after the defense has had the opportunity to comply with the court's order regarding expert witnesses, we can revisit the matter again, and I can still re-instruct the jury at any time during the course of these proceedings regarding discovery violations.
The problem is that in our proffer to reopen, we would like to include those expert witnesses.
All right. Well, when I hear the proffer, I'll rule on it. But my inclination this morning is to go forward with the jury, have Mr. Cochran complete his opening statements, then I'll hear your proffer, and we'll see where we are. All right?
Can we at least have the defense give us the names of the witnesses they intend to call as to the matters I described, the tire tracks, the shoe prints, the finger cut, the rheumatoid arthritis, those matters?
All right. That seems to me to be a clear intent to call those persons as witnesses, so I think their identity needs to be disclosed, or should have previously been disclosed. Mr. Cochran? I agree that her request is well taken.
Certainly not operating this for this.
All right, well, we'll have to take a 20-minute break just to bring the jury down in any event, so you and Mr. Douglas can accomplish that in that 20 minutes. All right. I'm sorry? Certainly.
Before Fishman.
And Mr. Darden, when do you anticipate Ms. Fishman's will be necessary?
February 9th.
All right, are you Cora Fishman? All right, good morning, Ms. Fishman. I'm going to order you to return to this courtroom on Thursday, February the 9th at 9 a.m. without further order, notice, or subpoena. Do you understand the order, ma'am?
Yes.
All right, counsel, your appearance for the record.
Yes.
Andrew Rubin, I'm here representing Mr. Shin.
Morning, counsel. Good to see you again.
Good to see you, Your Honor.
All right. Thank you, counsel.
Thank you.
One of his clients named a cat after me.
Oh,
All right.
that's so cute.
Ms. Clark.
Did you, is the court indicated when I'm recess? I would like to hear the names.
Ian, Mr. Cox.
I wonder if the cat's name is just Ito or Judge Ito. I'm going to name a cat Judge Fleischer. I have a cat here I can name Judge Fleischer. I'm going to. It's done. It's too late.
Indicated he and Mr. Douglas were going to prepare a list for you in the 20 minutes that it takes to bring the jury down. All right. Let's have the jury, Deputy McNair. Thank you. Mr. Douglas, you had something you wanted to say before we start?
I would, Your Honor. Thank you very much. Your Honor, in addition to the comments and to the objections that we lodged with the court in chambers, I would like to add one more point that was just brought to our attention recently. And that is, Your Honor, our review of Section 1054.5b does not specifically authorize a judge to instruct the jury that a discovery violation by defense counsel, for example, may be considered by the jury bearing on the credibility of witnesses. And I think that there is the danger that the language of the proposed instruction by the court gives such a suggestion. Nor does case law, Your Honor, authorize such a jury instruction. Indeed, we submit that it would be completely irrational to make a connection between a lawyer's discovery obligations and the credibility of an independent witness. I think, Your Honor, that there is a danger by such a nexus triggering profound state and federal violations, both due process and of a Sixth Amendment nature, and I would urge the court to strike that connection in the court's ruling. Secondarily, Your Honor, I respect, though I respectfully disagree, with the court's finding that the violation to turn over the witness statements of Ms. Kirchhoff was intentional. I suggest that before the court can properly make such a ruling, that is, that there was an intentional violation to gain tactical advantage, that the court should most properly consider that aspect within the context of a sworn declaration that I would like to have the opportunity to submit myself to this court so that the court could then have facts upon which the court might make such a finding if the court is ruling that a violation is being imposed and a sanction is being imposed based on the court's belief that there was an intentional violation rather than an inadvertent accident, as we contend.
All right, Mr. Douglas, I'll give you leave to file whatever affidavit you wish. However, the court's ruling will stand. The court's finding stands. Thank you. Ms. Clark, you're standing for a reason?
No, I submitted the article to the court
Yes.
of Dr. Walker. I've also been informed by several people that she was on. I've been informed by several people that she was on Good Morning America this morning, indicating that she had had some 40 hours of interviews with Mr. Simpson. In light of the fact that Mr. Simpson is in court most of the day, every day, that would preclude her physical capability of having amassed that number of hours unless she had been retained quite a long time ago. And all of this flies in the face of counsel's direct assertions to the court that she had recently been retained. It's now been exposed to be an absolute falsehood.
No, I think that was Attorney Douglas. I think.
And I think that the article as well in the LA Times makes that clear also, that she was actually contacted through Geraldine Stolle in the summer, which makes it physically possible to have amassed that number of hours. So I think that what the court has before it is further impeachment of defense counsel's most recent assertions even of having been recently retained.
Ms. Clark, I have before me a photocopy of a press release that Ms. Walker released on, Dr. Walker released January the 26th, and the ending paragraph reads as follows, quote, "As we began to examine the evidence over the past 5 months, which included some 40 hours of evaluation of O.J. Simpson himself, we realized that the potential for long-term harm to battered women was present if the facts, patterns, and significance of the battering in this case were misinterpreted, distorted, or otherwise misused by either side." So the fact that they've been examining the evidence for the past 5 months, I think, supports your position that, in fact, there was a relationship prior to just last week. However, having said that, the defense was not in a posture to know whether or not testimony by Dr. Walker would be relevant until the court ruled on the domestic violence issues, at which point the court, having allowed testimony of some incidents and having excluded testimony as to others, then clearly set the issue before the jury. So I accept Mr. Cochran's representation that he did not formally make a determination whether or not to call Dr. Walker until after the court's ruling on domestic violence. But that also causes me to believe that if there's been 5 months of preparation, that there ought to be some notes around.
Exactly, Your Honor. Not only that,
But as I indicated to you, we'll take up the issue of experts after you've had the opportunity to look at the list that was given to you in chambers this morning by counsel.
as I recall Mr. Cochran's representations to the court when last we confronted this issue, my understanding was, and I'm sure the transcript will allay any questions we have about this, will resolve those questions. I believe the representation made was that she had not been contacted until earlier that
Counsel,
week.
we'll go back and look at this again. We've argued it enough, I think. The record's clear what's there. I'll have my staff go back through the transcript and see what's there. But I think my observation as to what occurred here is probably accurate.
The court was not left with the impression by Mr. Cochran that he had just recently contacted her?
No, I'm saying I accept Mr. Cochran's explanation that a formal decision to call her as a witness was not made until after the court ruled on the domestic violence issue. I accept that as being a reasonable explanation here. All right, but the issue whether or not there ought to be some reports back there, I don't know. But it's an issue that we'll address later, as I indicated to you. Thank you.
But while you're addressing that, would you also address the fact that Dr. Walker could not get into the jail without your orders? She never saw Mr. Simpson until you did the orders.
Mr. Cochran, I'm aware of all those things as well.
And the orders were like in December and afterwards, and so you know when she saw him. She saw him during when he was not in court.
Seems to me you're ahead, Mr. Cochran, on this one.
So I want you to look at that.
That was Mr. Cochran because he said it twice.
Okay. All right. In chambers, the record should reflect that counsel did suggest to me that I include in my admonition to the jury, my instruction to the jury, some language to the effect that the failure of the defense attorneys to comply with the law of discovery is not evidence of the defendant's guilt and should not be considered as such. I think that is a good suggestion, and I will include that in the instruction to the jury because that is, in fact, the state of the law. All right. Deputy McNair, let's have the jurors, please.
They're done fighting? It's over? We get to go forward now? That's crazy.
Did you hear the decision about the censorship prosecution?
I made a decision. Yes, I did. I indicated I would not do that.
Now we get to hear what Judge Ito is going to say to the jury about all this. Oh my gosh.
Yes.
For the record, that crackling is them this time.
Excuse me, Mr. Cochran, Mr. Douglas, why don't you be seated until I finish re-instructing the jury. All right, counsel, be seated, please. Thank you. All right, good morning, ladies and gentlemen. Everybody seems to be smiling today. Good. All right, ladies and gentlemen of the jury, I need to advise you of certain things. First of all, one of the attorneys has fallen ill, Mr. Hodgman, and he is not with us today. However, the parties have elected to proceed in his absence. Also, I need to instruct you and to explain to you some of the reasons for the delay that we have had over the past 2 days. Ladies and gentlemen of the jury, the laws governing criminal procedure in California require that each side disclose and give to the other side the names of the persons they intend to present as witnesses and any written record or recording of the statements made by these witnesses. The law also requires the disclosure of any real or tangible evidence. These disclosures must be made before trial if the witnesses or evidence are then known. These laws exist to promote the ascertainment of truth in trials, to save court time, and to avoid the necessity for frequent interruptions and postponements. During the course of the opening statements, defense counsel mentioned witnesses who had not previously been disclosed to the prosecution.
Is what she's transcribing showing up right here?
Or whose written statements were not given to the prosecution before trial as required by law. This was a violation of the law and one of the causes of the 2-day delay, including the absence of Mr. Hodgman. Keeping in mind that statements by the lawyers are not evidence, you are directed to disregard the comments of defense counsel during his opening statement as they pertain to the following potential witnesses: Mary Ann Gerchis, Michelle Abduram, Mark Partridge, Howard Weitzman, Skip Taft, Christian Reichard. If and when these witnesses are presented to you during this trial, you may consider the effect of this delay in disclosure, if any, upon the credibility of the witnesses involved, and give to it the weight to which you feel it is entitled. Please note, however, and this is important, please note that the failure of the defendant's attorneys to comply with the law is not evidence of the defendant's guilt and should not be considered as such by you. All right, ladies and gentlemen, we will now conclude the defense opening statement. Mr. Cochran, do you wish to conclude your remarks?
Yes, I do. Thank you very kindly, Judge.
All right.
As you know, College of Defense, College of Prosecution. Good morning again, ladies and gentlemen. This morning, again, I'll be assisted by Mr. Carl Douglas with regard to some graphics that we have, and by Mr. Howard Harris here also with regard to the graphics. As you recall from our discussion last week, in discussing the evidence, we've talked about the coroner's office and talked about what we expect the evidence to show regarding their shortfallings. We've sought to reply to the things that have been brought up by the two prosecutors in their opening statements. And I believe that at the end of the day, we'd reached the point where I told you we were about to discuss the Los Angeles Police Department and their handling of this matter. I think the evidence will show that the Los Angeles Police Department was the main investigating agency in this particular case. The two main detectives are Detective Philip Van Adder and Detective Tom Lange. They're from the Robbery Homicide Division, and they were assigned this case in the early morning hours of June 13th, 1994. In the course of our discussion today, we will be talking about the evidence which was seized or collected at the scene of Bundy and also at Rockingham. And we have the first graphic there. Under this scenario, we expect to be talking about the integrity of the evidence. That is, whether or not this evidence is capable of your belief, whether or not it's evidence that is correct and appropriate. How was it collected? And so, for the graphic there, all the evidence picked up at the Nicole Brown Simpson condo at the top, the evidence picked up at the Simpson home on Rockingham, the evidence from the Bronco, any blood, all went first through the LAPD there. And then ultimately from LAPD, it was sent out to the various labs, be it the FBI, Cellmark, or the Department of Justice. This graphic seeks to put this in perspective. You can see the LAPD then remains a focal point in their collection of all the evidence that you're going to be required to look at. We expect the evidence will show that this evidence that was collected at these various locations that you've just seen was contaminated, compromised, and ultimately corrupted. In the course of the evidence, we expect to show that. Next. Now, briefly last week, I spoke to you about a detective named Mark Furman. Mr. Furman and his partner, Mr. Phillips, worked West Los Angeles homicide. And they are the two detectives who first were assigned to this case before robbery homicide got involved. Robbery homicide is downtown, I think the evidence will show. These two detectives worked in West Los Angeles where these crimes had occurred. And they were the first ones to arrive at the scene.
I think what she is typing is going into the word processor. I don't think it's picking it up and speech to text. I think what she's typing is hooked up to the word processor and it's going in that way.
Scene. Although you didn't hear about Mr. Furman in the course of the opening statement of the prosecution, we think he'll be a key witness in this case. Let me tell you why I think he'll be a key witness. I believe the evidence will show that he and his partner, Detective Phillips, arrived at that scene sometime after 2 o'clock in the morning. The evidence will show these bodies were found somewhere around 12:15 on June 13th, 1994. That after arriving at the scene, Mr. Furman did a number of things. You saw him in one of the pictures last week where he was pointing down at allegedly the glove and the cap that was under some shrubbery, if you recall. That was a picture of Mr. Furman at that point. You notice that he had his shoes were not covered, that he'd walked in that location at that point without shoes being covered, that he made a number of discoveries at that particular point, that there was a photographer at some time at that scene at the Bundy location, that this photographer was then summoned along with Phillips, his partner, and Van Adder and Lange to go over to the Rockingham address. We expect the evidence will be that presumably they were going over there to give notice to Mr. Simpson about the death of his ex-wife, and presumably that the children were in police custody at that point. Apparently the parents were not notified of either Mrs. Nicole Brown Simpson or the Goldmans at this point, but they went over to O.J. Simpson's residence. You recall also I told you last week that Detective Furman had previously had contact with the Simpsons. He had responded to the so-called 1985 incident. He didn't write a report at that time, but in 1989, he wrote a written report. In that report, he talks about the incident of the 85 incident being indelibly impressed upon his mind. So he had had contact, had been to the Rockingham location. Now, the evidence, I think, will show that he will allege that the reason why he was still leading Detective Van Adder and Lange over to the Rockingham address is because he knew where it was. But I think the evidence will also show from Detective Van Adder that he, too, had also worked in West Los Angeles, and he knew the way over there. But at any rate, I think you'll find that the evidence will show that all four of these detectives, this is prior, of course, to the coroner ever being notified, leave the Bundy crime scene, and they go over to Rockingham. Once at Rockingham, Detective Furman, of course, now by this time, the case is now in the hands of the capable individuals from downtown robbery homicide. He continues to play an integral part in this case. I think the evidence will show that he, in looking at the Bronco, now it's still, by all accounts, I think, still dark outside, but he's looking at the Bronco. It's now maybe getting close to 5 o'clock in the morning, maybe the light's about up. He discovers what he believes is a speck of blood on the door. This is Detective Furman. He discovers some more blood allegedly down toward the bottom of the door. That at some point, when these officers can't rouse anybody at the location, Detective Furman is the one who climbs over the wall to go into the premises. That once in the premises, he's the one who interrogates Mr. Cato Kalin. That he's the one who also, after talking to Mr. Kalin, goes back and finds this glove, the alleged right glove, at Rockingham. We have now for you some video relating to Detective Mark Furman, and I'd like for you to listen to what he has to say with regard to the glove. Now, in fairness to Detective Furman, the question he's been asked is about the glove, and they talk about the glove. But in his responses, you'll see, he at some point talks about seeing them at the foot of Mr. Goldman. Mr. Harriser?
How far would you say you were from where the bodies were located?
I was directly above the female victim, which was probably 3 feet. The male victim would have been 10 feet, 12 feet.
All right. And from that vantage point, you first observed the glove that you told us about?
Not first, no.
When did you first observe it?
We had flashlights. We were looking at the female victim. We looked at the male victim. I noticed the glove when I walked around to the... After I exited the residence the first time, I walked around to the side, or the north side, north perimeter of the 875 Bundy. There's a iron fence, and through that iron fence you can get very close to the male victim. And looking there, I could see them down at his feet.
You recall, and you heard the testimony that I could see them down at his feet. And the question we'll be seeking to establish in this trial is when he said he saw them down at the feet, was he talking about 2 gloves at that point? Now, also, this detective plays a critical role as he remains at the Rockingham location. You recall last week I mentioned that we expect to call a witness by the name of Rosa Lopez at some place in the case. Rosa Lopez lives next door to Mr. Simpson. She is a lady who's employed by the family there. She is their housekeeper. And there will, we believe, be testimony that Detective Furman had a conversation with Rosa Lopez on the early morning hours after about 7:30, 8 o'clock in the morning on June 13th, 1994. And at that time, Rosa Lopez shared with him her observations that she had been outside the night before and that the Bronco vehicle parked there at the curb at Rockingham was parked there at approximately 8:15, 8:30. It was parked at a kind of a unique angle. And she had reason to remember that as she went outside to walk her dog. She will also testify that she came back outside to walk that same dog at about 10:20 p.m. She saw the Bronco parked in that same location that had not been moved. That the next morning, when Detective Furman had spoken with her, the Bronco was still parked at that same angle, as though it has not been moved all night. She will share with you what, if anything, she said to the detective that morning. You will find out whether or not he reduced any of this conversation to a report, whether or not that report was ever forwarded to anybody, whether he told any of the detectives about it. We expect that she also indicated to Detective Furman that Mr. Simpson left this residence somewhere around 9 o'clock, and there'll be testimony that he and Mr. Cato Kalin went to get the McDonald's hamburger. But she was aware and heard his voice when he left, that she heard what she believed to be prowlers during this period of time and became quite frightened. I expect she'll also testify that she heard Mr. Simpson's voice at around 11 o'clock or a little after that. And when she heard his voice at 11 o'clock, it appeared as though he was leaving. And she did not hear his voice anymore that particular night. That after Mr. Simpson's voice was no longer heard, after he presumably had left the Rockingham residence, that she heard men's voices beginning at about 12 o'clock, lasting until about 3 o'clock in the morning. She was not able really to fall asleep until perhaps 4 o'clock that morning, and was awakened because I think the gardener came that morning And she also had this conversation with Detective Furman, who came and showed his badge and then came inside of her house. So we think that, in truth and fact, Detective Mark Furman will play a very, very critical role in this case regarding his testimony. Now, let's go back.
Well, that statement aged well. Mark Furman will very much play a big part in this.
If we're going to talk about the LAPD, and let's look at the statements regarding the coroner. You'll recall last week I indicated to you that the coroner's office for some reason wasn't called initially. They arrived at the scene almost 10 hours after these bodies had been discovered. Let's look for a moment using the Elmo with Mr. Harris as at the sequence of what took place, and then for the record I'll read certain things into the record from the transcript, Your Honor. Is that as clear as it's going to be? The underlined portions I will read for the record. This purports to be, and we will establish at the time of trial, this is a conversation that took place on June 13th, 1994, at about 6:49 in the morning, just before 7 o'clock. And it's a telephonic communication between the deputy coroner, Paul Willis, and Detective Phillips of the LAPD, Phillips being Furman's partner. Detective Phillips, I got a double homicide that we want to let you know about. It's going to be, the press is going to be crawling on us like ants when they find out what's going on. Detective Phillips, this is the first call, and we got a lot of work to do yet. But we need to get you guys rolling out here so we can get these bodies, which are visible from the street, out here as soon as possible. If I can digress for just a moment, you recall that he's saying this is the first call from Phillips to the coroner's office at 6:49 for bodies that were discovered by the police at 12:15 a.m. He also says something else that I think the evidence will show is very interesting. When he says that we're going to get you rolling out here for these bodies which are visible from the street. And you'll recall that when I spoke to you last week about Ellen Aronson and Dan Mandel walking past this location at 10:25, not hearing anything, not seeing anything on the sidewalk directly in front of 875. And you have seen the other photographs, what you could see from that sidewalk, and it's clear from his statement, you could see these bodies, and of course there was all the blood with the scene. Continuing on, we kind of not following procedure, but we're kind of asking a favor, and kind of work a little bit on this one. So we have the detective saying at this point they're not following their own procedures and they're asking the coroner's office to do them a favor and cooperate with them. Thank you, sir. We'll go to the next page, page 240 for the record. This is Detective Phillips again, still talking to the deputy coroner, Mr. Willis. Detective Phillips. Well, you can see them, from the street here. They're a little off the sidewalk here in front of the house. But the problem is, when this thing breaks, we're going to have news from everywhere here. It's going to be a high-profile type deal. It's the ex-wife of a very prominent sports cast star or sports celebrity. Then he's asked a little bit above, he says, okay, I'm going to have to trust you on this. It's O.J. Simpson's ex-wife. That's Phillips telling the coroner again. And he goes on to say, the coroner says, oh boy, okay, and Phillips says, and he's in Chicago, and Willis says, he does not know anything about this, and Phillips says, he knows now, and that's what's going to break this thing wide open. Next page, page 241, Mr. Harris, sir. Now, Mr. Willis hears this, and I think the evidence will show he's the coroner. He wants to get rolling. And on this page, in page 241, here's what Willis says. Okay, you want us rolling out now. And then Detective Phillips says, hold on a second. Tom, and I think the evidence will show when he says Tom, he's talking about Detective Tom Lange. So you're not confused, there's two Tom Langes in this case. It's the Tom Lange who sees Mr. Nicole Brown Simpson out on the sidewalk, and he sees the Mexican gentleman behind her at 10 o'clock, and there's Detective Tom Lange, who is Detective Van Adder's partner. So he says, hold on a second, Tom, you want the coroner now? No, hold on a second. How long? Okay, you're just getting the first call. And then Phillips goes on to say, we'll give you a call back when we want them moved. Presumably meeting the bodies, I suppose. Detective Phillips, it's probably going to be about an hour to an hour and a half. So here we have them calling more than 6 hours the very first time, 6:49. Then when the coroner wants to roll, or says he wants to roll now, they then say maybe an hour to an hour and a half later. Move to the next page, please. All right. Phillips says, what I'm going to do is I'm going to give this to the supervisor because I'm leaving now. Phillips says, all right. Willis says, and tell them that you're going to be calling back about an hour and a half. Phillips says, okay, and again, we don't want that out. That essentially ends the first conversation.
I don't understand all that. Like, I don't understand what the big deal was at any of that. He is a prominent sports celebrity. It will break it open. The press will be there. You would think with something like this, the crime scene experts want to make sure they take a lot of, they want to inventory. They want to take photos. They want to make sure everything is the way it should be, and they don't want the coroner to take the body away right away because they have to do all that, right? I mean, why is that they're not doing their job? It sounds like they're really, really, really doing their job.
Put it in context. Let's see if and when they call back. And we will present evidence to show that at about 8:08 in the morning on June 13th, 1994, there was, in fact, a second conversation between Detective Phillips and a Mr. Richard Heath, then of the coroner's office. Detective Phillips says, we already gave you guys the first call several hours ago on Monday. Heath, yeah. Phillips, okay. Can you give me an ETA, an estimated time of arrival, if you started rolling now? Some conversation with Phillips, with Heath rather. And Heath goes on to say, yeah, my name's Heath, H-E-A-T-H, and I could give you approximate arrival time of driving time from the main office in about maybe another 15 or 20 minutes added to that. And Phillips says, okay, so you're talking a good 45 minutes then? Detective Phillips, to an hour. Next page, sir. Detective Phillips says, you're not going to roll them for an hour? And Mr. Heath responds, no, we'll be there within 45 minutes to an hour. Now, we think that this evidence is a very important evidence because it starts right at the beginning of this investigation by the Los Angeles Police Department. First, they've already failed to notify. Then when they do notify, they've got so much work to do yet. We know that the coroner's office doesn't come out there until they don't get the final call till 8:08. And so we know then perhaps, according to this man, Mr. Heath, it's at least 1 hour or so after that before they even get out to the scene. You've heard me mention Detective Van Adder, who is the detective in charge of this scene, a very experienced detective from robbery homicide. And as with all of the witnesses in this case, their credibility will be questioned, and we'll be looking very closely at their credibility and what they did that night and how they conducted themselves. We must do that also with Detective Van Adder. Detective Van Adder, on this particular morning at about 10:45, sought a search warrant. As the evidence will show, Mr. Simpson was not in Los Angeles, he's in Chicago. The detectives had gone over the wall first, but thereafter they sought a search warrant. That's not relevant, but what is relevant is the credibility of the detective and what he said to the judge in seeking to get this search warrant. Mr. Harris? And what is the number? We should be giving numbers.
That is D40.
All right. You'll see in this number.
D41.
This is D41. It's a search warrant and affidavit, and you'll see it signed by Philip L. Van Adder on June 13th, 1994, at 10:45 in the morning now. This is after they've gone over the wall, et cetera, and this is an application to a judge try and go into the house and search. A sworn affidavit. All right?
42.
All right. And this one, Mr. Hurst?
43A.
All right, you pull that up.
B43B.
Now, here's what the detective in a sworn affidavit says to the judge to get this warrant. It was determined Simpson had left on an unexpected flight to Chicago during the early morning hours of June 13th, 1994. Now, we will introduce evidence to show that that was a direct misrepresentation and untruth, that the police knew from Cato Kalin, in the conversation with Arnell Simpson, that Mr. Simpson had been on a long planned trip to Chicago.
B44.
And he indicates that himself, that by interviews of Simpson's daughter, and that would be Arnell, and a friend, Brian Kalin, he writes that in. That's what's in the writing to the judge to verify the fact that O.J. Simpson is like gone on this unexpected trip, like run away to Chicago. And he uses that as a reason in talking to the judge.
B46A.
The next thing I'd like to show you is that is the statement from Brian Gerard Cato Kalin. What's that number, sir? Now, thank you. This statement from Brian Gerard Kalin, you notice this statement was taken by the police June 13th, 1994 at 6 o'clock in the morning. Remember I told you that Detective Furman went into his room and talked to this man in the early morning hours. And Simpson, the statement is, Simpson told him he was going to Chicago for Hertz Corporation. So they knew why he was going to Chicago. They knew it was not an unexpected trip. So this was a lie when they were talking to the judge at that point.
B49. B50.
The next issue of credibility deals with the detectives indicated to the judge who they were seeking the search warrant. They observed what appeared to be human blood, later confirmed by scientific investigation personnel to be human blood on the driver's handle of the vehicle. Well, the evidence will show that they may have confirmed it at some point much, much later, if ever, but they had not confirmed it at 10:45. It was not human blood. They could not confirm human blood. So that was another misstatement to the judge at that particular point. Now, in addition to that, and I'll read these for you, the other inaccuracies of some importance that we think the evidence will show are as follows. The detectives in seeking this particular warrant never disclosed to the judge the manner in which entry was made. That is, they'd already climbed over the wall. They never bothered telling the judge that. And then finally, the final inaccuracy that I think you will find of some great relevance, the fact that Mr. Simpson had in fact been contacted by Detective Phillips and had volunteered to come home, taking away from the warrant any implication that he had somehow fled the scene. That was never done. Now again, this is the evidence from their files and based upon what their lead investigator said to a judge. And at some point in our opening statement today, I want to characterize for you how Mr. Simpson conducted himself in the early morning hours of June 13th with the way that the detectives conducted themselves. This brings us then to a discussion of the Bundy crime scene. You recall briefly the other day I talked to you about, we think the evidence will show ultimately this was a place of the gathering of the evidence. And that we think the evidence will show that it is very important at the crime scene to secure this area. That people should not be walking through the evidence, should not be tracking up the evidence, should not be touching things without gloves, should be in some way protected. This evidence is all very, very sensitive. We would expect that hopefully by the time of trial, you will actually have some footage from local televisions of how the detectives and how many people were out there and whether or not they were, in fact, wearing anything over their shoes. You've already seen in the prosecution's opening statement Detective Furman's shoes and how they existed at the time. We think the evidence will show that this scene was tracked and traipsed up, and the gathering of evidence was a complete disaster. And we feel that the evidence will be shown to be contaminated, compromised, and corrupted, as we've indicated earlier. Now, Your Honor, before we show this next graphic, I want to say a word to counsel, and you may want to use your script.
I've already. I'm going to direct photographers not to attempt to take photography of the screen in the courtroom.
I've spoken so the family of Mr. Goldman will be aware with regard to this picture. This is the only picture that in any way could cause any concern, Your Honor, but we'd like to move on at this point. Now, this purports to be a photograph of Mr. Goldman's body while still at the scene of the Bundy location. And you will notice several things about this particular photograph. I believe the evidence will show, first of all, that the lady whose shoes are there, these shoes are uncovered. She's standing on some kind of a white sheet or something of that nature. You can see blood on this photograph. She has nothing over her shoes. She's standing there. You see the body. And you'll see something else interesting. You'll see some gloves. Now, these gloves have blood on them. And these gloves have now been dropped on Mr. Goldman's body. Now, these gloves are, the evidence will show, are typical of the kind of gloves that are used at the scene to pick up evidence or to collect various and sundry things. And yet you see these gloves now found on Mr. Goldman's body in this fashion. And we think this is typical of the way things were conducted at that particular location at that time.
Sorry, that was D.
Thank you.
Thank you, Mr. Hill. We expect, as we indicated last week, to show that based at this particular crime scene at Bundy, there'll be a number of things that we expect the evidence to show. That one of which is this crime scene and the patterns of the crime scene.
Somebody put bloody gloves on his body, and they have a picture of it. I mean, yeah, that sounds pretty contaminating to me. Even if it's his blood, though, I mean, which they can't prove because there's another body there.
Scene are consistent with a major struggle. Mr. Ron Goldman's blood, as I told you, should be all over the perpetrator, especially in the upper and middle parts of the perpetrator's body. You'll recall that Detective Furman's description this morning, we described this rather small area where Mr. Goldman's body was found. You recall he talked about a fence, and you've seen, I think, some pictures. You'll see a tree in the area. It's a very small area. Like he had to go outside to look outside the fence to see where the body was. A very small area. And I think that you'll find if there was this major confrontation, and you recall last week Mr. Goldman's hand, that I indicated to you, I expect there'll be testimony that that hand came in blunt force trauma with one of his perpetrators or one of the perpetrators there. And there would be some marks, some injuries, it would seem. Plus, there are trees. There's this fence. And there was a violent struggle. So that if you recall the pictures of Mr. O.J. Simpson last week, you can understand that it will be important evidence as to the lack of any marks, bruises, or anything of that nature. In the area, we expect the scene to also show that in the area where these murders took place, there are a number of footprints in a very small area, which means that most likely the perpetrator had to be there for a period of time and that there was this pattern of fighting. I think the evidence will be in this case that Mr. Goldman's blood is on different areas of the location, which means that
I think so, because didn't they have something like that in E.T.? in the movie E.T.? And that was back in the 80s. This is the 90s.
he too was moving around. So there was this kind of a confrontation or this fight that went on over a period of time as one is fighting for one's life. And as you know, it was a violent struggle in which he ultimately was stabbed some 31 times. Now,
Actually, I used to work on a printing press where we wore the Tyvek, because we would get ink all over us if we didn't. And I had it then. So, yeah.
the prosecutor, 30 times. The prosecutor indicated to you all this happened very fast. And I think that you'll see from the evidence that that's not exactly correct, given the situation when one is fighting valiantly for their life. There was some testimony last week about certain blood drops, I think, by the prosecutors that were at or near the many footprints. And I think that you will find that it'll be very unusual and that it'll be a remarkable occurrence that there are only 4 drops of blood that they talk about and so many footprints. Further, we'll look very closely during the course of this trial at the glove, at both gloves. We'll look at the glove found at Rockingham, the right glove. We'll look at the glove found at Bundy. And we'll be looking to see whether or not there are any cuts on those gloves consistent with any cuts or anything on Mr. O.J. Simpson's hands.
We will be looking at those gloves, guys.
We expect that there, as I mentioned to you last week, there will be fingerprints on the railings that are fresh at Bundy. And we think that the evidence will show those fingerprints are not O.J. Simpson's fingerprints. That there are hairs on the cap and the glove at Bundy that are not O.J. Simpson. Thank you, Mr. Harris and Mr. Douglas. Now, you'll see in the exhibit up on the board, the large board, the video exhibit, you see a lady against the Bronco. That's the Bronco that you hear a lot about, and that's a photograph taken on June 13th, 1994. You'll see the tow truck behind the Bronco. And you see this lady up, apparently peering in the window of the Bronco. And we expect to show that this Bronco, which you heard this important evidence therein, was not secure, that people such as this lady graphically were allowed to walk up, touch it, and when that Bronco left that location, there'll be evidence that there were at least 2 coffee stains on the hood of the particular Bronco, that it wasn't secured, that it wasn't preserved, that it wasn't made so that you could count on that evidence.
That is D63.
All right.
D64.
All right, now thank you, Mr. Harris. The Bronco was, of course, impounded. All right, Mr. Harris?
D68.
Okay, we did it. We made it through another little tiny portion of his opening statement, but at least we're back with the jury in the room today, right? That's good. That's a step forward. So next time, tomorrow. Wait, what is today? No, not tomorrow. In 2 more days, then we'll get to see the end of his opening statement. Maybe, I don't know. I don't even know. And then we'll get to see them rebut with. I don't even know what Marcia Clark's going to say now with all the things that have happened when she gets back up. But I know it's it's probably going to be good. Oh man, we got a lot. We just had a marathon of trials, guys. So now we need to go and watch kittens or something to decompress. Thank you so much for coming out. I really, really, really appreciate it. I will see you for more opening statements. Nope, in 2 days. Bye, guys. See you soon.